Right. Thank you. So I will focus on the unique features of the ECOWAS human rights system, and then I'll also attempt an appraisal of the ECOWAS human rights mechanism, and then under that I'll look at the successes the ECOWAS court or the ECOWAS human rights system has struck, and then I'll also touch on a few of the challenges that it has, and I'll conclude with some suggestions of how I think some of these challenges can be resolved. But before I go on to the unique features of the ECOWAS human rights system, I just want to make a brief comment on the relationship between the regional protection of human rights and integration. So we know that every regional integration arrangement has its ultimate objective, the advancement of the socio-economic well-being of the peoples of the integrated state. So to that extent, even if the instrument that sets up the regional integration arrangement does not make an explicit reference to human rights, there is still an implicit objective of ensuring the socio-economic rights of the individuals in the state, including the rights of health, work, etc. So to that extent, there is a linkage between human rights protection and arrangements. Also, we know that if, for instance, there is a gross violation of human rights in a particular state that has the potential to cause instability, that will derail the integration agenda. So to that extent, the non-protection of human rights could also have an impact on the integration agenda. So to that extent, I would argue that regional integration and protection of human rights are mutually reinforcing. So regional integration agenda, a regional integration project can promote human rights, at least socio-economic rights. And also the promotion of human rights can advance the integration agenda, because if you do not protect human rights, you may, and there is gross violation of human rights, like the cases we saw in the early 90s in Liberia and Sierra Leone, have instability in the whole region, and the integration agenda itself will be disrupted. So to that extent, there's a clear link between human rights protection and regional integration. Now, to the unique features of the ECOWAS human rights mechanism. So ECOWAS has not always been an institution that was in the human rights space. So when you look at the Lagos Treaty that set up ECOWAS in 1975, there was no specific reference to human rights. The closest it came to was a carve-out clause that permitted states to impose measures for the protection of the human, animal, plant life, which is what you find in trade agreements. Now, so fast forward to 1993, the ECOWAS adopts the ECOWAS revised treaty, and under Article 4G, ECOWAS establishes as a fundamental principle the promotion, respect, and protection of human rights consistent or based on the African Charter. So that sort of laid the foundation. But even prior to that, because of the situation in Liberia and Sierra Leone, ECOWAS had adopted earlier on the Declaration of Principles, political principles, which laid out a blueprint for the protection of human rights. So basically, the revised treaty sort of confirmed or put on a firm footing, legal footing, the aspiration that had been expressed in the Declaration of Political Principles. Now, so Article 4G of the revised treaty, therefore, is the foundation of the ECOWAS human rights system, and that was reinforced in 2005 with the mandates given to the ECOWAS court to hear human rights cases. So if you're looking at the unique features of the human rights system under ECOWAS, I could talk of three basic things. First, the human rights mandate of the ECOWAS court, which is the sort of the human rights court of the region. And we know that the ECOWAS court is not a sole human rights court. It's not. It has other mandates. It's the community court, it's the community arbitration tribunal, and it's the administrative court as well. So it has been given an additional mandate of the human rights jurisdiction. Now, when ECOWAS pivoted to human rights, I think there would have been a number of options open to it. It could simply have just encouraged its member states to sign up to certain regional human rights systems like the African human rights system, or maybe international ones like the ICCPR, etc. So its role would have been limited to just encouragement and peer pressure. Or it could have decided to establish its own special human rights system by adopting a protocol of human rights and establishing either a commission or a court. And then the third option would have been to probably repurpose existing institutions to protect human rights. And I think this is the third option that ECOWAS by repurposing the existing ECOWAS court to hear human rights cases. So the human rights court within the ECOWAS system is sort of a repurposed court to deal with human rights, and not sort of like an original or a court set up purposely to deal with human rights. Now, the second unique feature, I think, is the sources of human rights law in the ECOWAS human rights system. So we know that ECOWAS has no protocol, human rights protocol or charter. So technically, the sources of human rights law may vary depending on the case before it and depending on the instrument that the court, the respondent state has ratified. That said, I think there are some uniform sources of human rights law within the ECOWAS system. Now, we can first talk of human rights norms that are of customary character, because the Human Rights Committee and other human rights bodies have recognized that there are some human rights norms that are customary law, like freedom from torture or freedom from slavery, freedom from arbitrary detention, etc. So those norms, if they are considered to be customary, would apply to all member states of ECOWAS, even if they have not ratified any treaties that specify those norms. Then I think the most important uniform source of human rights law within the ECOWAS is the African Charter, because as I've already mentioned, Article 4 says that the protection, respect, and promotion of human rights in ECOWAS is based on the African Charter. So to that extent, my view, even if there is a member state of ECOWAS that has not ratified, although all members have ratified, even if there is a member state that has not ratified, by virtue of Article 4G, that member would have impliedly consented to the provisions in the African Charter. So I consider that Article 4G sort of incorporates the human rights provisions of the African Charter into the community law of ECOWAS. And even if we disagree with that incorporation theory, I think we can still consider the African Charter as an important aid in interpreting the human rights provisions of the ECOWAS revised because of the doctrine of systematic integration, Article 31, paragraph 1C of the Vienna Convention of Law Treaties, which requires courts to consider the normative environment within which a particular instrument exists. Now, to the third and important feature of the ECOWAS human rights system, I'll talk about the policy of unrestricted access, which Justice Mwoki just discussed. And so generally, the requirement to access the court is basically that your application should not be a ghost application. So you must identify yourself, and also that the case should not be pending before another international court. So conspicuously missing is the assertion of local remedies. I'll return to that shortly, but then let me just now go into how effective the human rights system of ECOWAS has been. So we know that the ECOWAS court has had about 540 or 80 cases, I think the Richard said yesterday. And of that, the court has delivered judgments in about 130 of them, most of them on human rights cases. And so I think it's one of the most active courts on the continent and arguably in the world in terms of human rights protection. So that is to its credit. And apart from just deciding cases and giving relief to victims of human rights violations, I think an important contribution of the court has also been in the area of building the jurisprudence of human rights jurisprudence on the continent. And my Lord Justice Assefa mentioned this morning the award-winning case in Amnesty International versus Togo, which held that internet shutdown can be a violation of freedom of expression. So to that extent, we can see that the court has done very well on that front. That notwithstanding, I think there are some challenges to the ECOWAS human rights system. I think some of the challenges are external and others are internal within the court or the human rights system itself. Now, so the external challenges, I think...
You have less than 3 minutes more for you to run up.
Right. So the external challenges, I think, one, I would consider the changes in the composition and tenure of the court. We know that the court has a lot of cases due to the policy of unrestricted access, and so the reduction of the number of judges and also the change in the tenure of the members of the court from 5 years term renewable to a 4-year term non-renewable, I think makes the work of the court difficult because the court has a heavy caseload. And also, like the president of the court mentioned on the first day, it does not allow for institutional memory because the longer the judges stay on the court, they are able to gather more experience in deciding cases. And then the original staggered nature of the tenure will also ensure that there is no loss of institutional memory. So I think that's a problem. The other problem, I think, important, very important, is the low compliance rate with the judgments of the court. It has been said several times here that it is only at the moment about 30%. That is not encouraging, and I think that is also a problem. Now, the other problem, I think, which I think we can elaborate more on in the discussions, is the some aspect of the court jurisprudence which I consider to be a bit problematic, and that is specifically in reference to the exhaustion of local remedies rule. Now, international human rights courts or general international courts, when they have to deal with issues related to human rights, or even in the cases of crime, are supposed to be complementary to national jurisdiction. So, international court, the international jurisdiction is subsidiary to the national jurisdiction. So, states are the primary implementers of international law. So, international courts are not supposed to either be in competition with or to supplant national jurisdiction. And so that is where I find the court decision not to uphold the local remedies principle a bit concerning. Now, I find it concerning for two reasons. The first is for legal reasons, and the second is for practical reasons. Now, as far as the legal reasons are concerned, as Professor Wonke said, the local remedies rule.
It should be running up now.
Right. The local remedies rule is a rule of customary law. Now, the ICJ has held that the local remedies rule cannot be deemed to have been waived unless a state expressly, the treaty, waives it. So the mere silence of a treaty on the local remedies rule is not a waiver. That's the first point. Secondly, as I mentioned, the ECOWAS human rights system is based by virtue of Article 4G on the African Charter, which is sort of the primary document. Now, it is incongruous to suggest that the same states that subscribe to the local remedies rule under the African Charter have waived it and have ECOWAS. That for me is a bit incongruous. Now, the third reason why I find it concerning is that I think it will pose practical challenges to the court.
I think your time is up.
Okay, I'll run out on that point. Now, so I think it will pose practical challenges to the court because the policy of unrestricted access means that the court will have more cases, and with a reduced number on the court, etc., I think the court will operate under great stress, and the respect that we accord courts in part depends on the quality of jurisprudence they're able to produce. If the court has too many cases, including cases that can be decided by local courts, I think that will pose great stress to the court. And over time, it may not inspire the confidence that people ought to have in the court. So I think we ought to come to a middle ground eventually. And I think because my time is up, I will leave it at that. And then in the discussion time, I will consider that in more detail and provide what I think are some of the ways in which that can be resolved, and generally also on how we can make the court more effective and ensure compliance with these statutes. Thank you very much. So within the ECOWAS human rights system, what I meant was that because there is no specific human rights protocol or charter, the court can apply any human rights instrument that the state has ratified. So the particular human rights instrument that will be applicable will depend on the case. However, there are some human rights norms that are commonly applicable to all members, and that's where I mentioned that on the basis of Article 4G of the revised protocol, the African Charter is that common human rights norm by virtue of the fact that all states have ratified it, and even those that have not ratified it will still be bound by it on the basis of their consent to Article 4G. Now, to the Vice President's question, I don't want to leave an impression that I am against restricting access to the court. Far from it. As much as possible, I want people to be able to approach the court and to have their cases heard. But I also recognize the practical challenges that come with that. And that's why I sort of try to argue that there has to be a way for the court to mediate the delicate relationship between itself and national courts. Now, the problem is that I didn't say that the court is currently overburdened, but what I say is that the court will likely be overburdened, and that could affect the quality of its jurisprudence because it will be stressed with workload. And the second point, which I didn't get time to make because of the limited time, is that where a case can be resolved at local level, especially in cases where it is pending before national court, because the court has said that even if a case is pending before national court, it will still have jurisdiction because the list pendants is only applicable to international court. Now, so in those cases, I think there could be a friction between the court and local jurisdictions, so that the court's judgments are not self-executed. The court will have to depend on national political authorities and judicial authorities to enforce its judgment. So if national jurisdictions get an impression, whether real or perceived, that the court is in competition with it or trying to supplant it, there will be some hesitance in enforcement of judgment. So that's the point I make. And I think in mediating this relationship, what I argue is that I'm not saying the court should, if the state raises the question of local remedies, the court should, for instance, maybe decline jurisdiction. I think there could be a middle ground. The court could, for instance, instead of dismissing the case or declining jurisdiction, stay the proceedings. And let's say give the state time, maybe 6 months, whatever. If you want to resolve it by a national system, then within 6 months, go and resolve it. If you don't resolve it, then we'll go ahead and hear the case. I think that could be a middle ground to mediate between the relationship that the court has with national jurisdictions. And then I will conclude with the other points that I do not get the time to make, if you permit me. Is that okay, my lord? Right, just 2 points. So I think that a way to ensure effectiveness and compliance with the court judgment, I think we could learn something from the European Union. So under the EU Commission has the power to approach the European Court of Justice where a member state has failed to comply with with the court's judgment. And the court is empowered to impose financial penalties, either a lump sum or recurring penalties. Now, the ECOWAS has a protocol on sanctions. It has very elaborate procedures under the protocol on sanctions on the imposition of political sanctions. And then it also says that member states are liable for to be sanctioned if they do not comply with obligations of the court, including decisions of the court. But the protocol does not define exactly what judicial sanctions are or who should activate those sanctions. So I think a way to go around that issue would be for ECOWAS members to go back to that protocol and probably specify clearly who may activate those sanctions. Maybe the power could be given to the commission, or it could be given to even the registrar, I think, who is more apolitical and may be able to do that. So I think that is one way we can do it. And then I think somebody also mentioned earlier in the morning that we could also adopt political surveillance. So the African Court, for instance, reports its judgments to the AU Assembly, and then in its annual report also it mentions states that have not complied with the judgment. And then the AU Assembly has the power to impose sanctions. I think a similar system could also be adopted, although it's a naming and shaming process. I think normally states would not want to be shamed by their own peers, so I think that could also moderately assist in the compliance with the court judgments. Thank you.
Yes,